So I'm going to call the meeting to order. Roll call. Brad Phillips.
Present.
Joel Williamson.
Here.
Lee Warren. Barbara Evans.
Here.
Thank you. Matt Hart. I spoke with him yesterday, and he may not be calling in today, and I think this would have been his last meeting based on conversations I've had with him. Sean Emmerich.
Here.
Steve Reinhardt.
Here.
And then I'll let the staff introduce themselves.
Mark Moore, Standards and Enforcement Services.
Thank you.
Tony Renteria, Staff Attorney.
Gwen Jackson, Director of BLS.
Jennifer Wheeler, Education Manager.
Tony Slagle, Deputy Executive Director.
Thank you.
Oh,
Okay.
and Carrie, are you on the phone?
Is she not here?
No,
No,
she's
she's-
down.
She is. She's
Okay. Carrie,
Adrian
Mary
Arnott.
Lewis, General Counsel.
yeah, Carrie Lewis.
She's-
And then
she's-
Commissioner Ariaga.
Oh, and Commissioner Ariagua.
Commissioner Ariaga, are you on the phone?
I'm on the line. Yes, sir.
Okay,
great.
thank you. Okay, any of the visitors that are here, if you'd like to speak or have anything to address any of the agenda items, you need to fill out a form. And also, if you would like to speak while we're talking about agenda items or have anything to add to the discussion, I would ask that we don't mind, having you raise your hand if it's important, but you would need to stand up, identify yourself each time, and that way we can make sure that our meeting minutes are accurate. And it makes it easier for everybody to know who's speaking, especially for those that are on the phone. Okay?
Thank you.
All right, and discussion and possible action. Agenda item 2, to excuse committee members' absences, if any. And Matt Hart is the only committee member that is absent.
Did he say any?
I think he's got some family issues that I know are keeping him from being able to attend.
Yeah.
And his 2 years expires.
He's,
As well.
yeah, I don't think he's gonna be.
He told me that he would love to be able to continue to serve, but right now he's not able to. So maybe in the future he would. But yeah, come back. But right now he's not able to.
Okay, so we will excuse this absence.
We need a motion and a second.
We need a motion.
I'll make the motion.
Second.
I'll second.
Okay, so all in favor to excuse Matt Hart's absence?
Aye.
Okay, thank you.
Aye.
Thanks, Barbara.
Mm-hmm.
Okay, so did everyone, agenda item 3, ratification of the minutes of the October 15th meeting. Did everyone get a chance to look at the meeting minutes? And are there any changes? So can we have a motion, please, to approve the minutes?
So moved.
Okay, all in favor?
Aye.
Aye.
Thank you. Okay. Agenda item 4, general comments from visitors on non-agenda items. We have none. So we shall move on to agenda item 5, which is reports from the subcommittees. And Doyle Williamson, I'll let you go first with Standards of Practice Subcommittee.
We met this morning, established some guidelines on how we would move forward on decisions, and went through quite a bit of the material, the agenda items. We ended up getting all the way through this SOP to the point of the branch circuits, which we will take up next time.
Okay. And you have not scheduled a future meeting date
Not at
until
this
after?
point.
Okay. All right, and Enforcement Subcommittee?
Enforcement is not met.
And Education and Licensing Services?
Oh no, and just Education Subcommittee.
Oh, okay. Education, sorry, I've jumped down.
We have not met, but we're scheduling one as soon as Mr. Bragg comes back in country.
So,
That was
yeah,
brutal.
and Dr. Evans, if you, we're going to come up with a couple of dates and then send them to you if you're able to phone in for the Education Subcommittee meeting, hopefully sometime before the end of December.
Excellent.
Thank you.
That'll work.
So sometime before the end of December, we're hoping.
Yes, ma'am.
We're looking to see the possibility of the week of the 17th.
All right.
Not sure what's up.
Okay. So, agenda item 6, we will move on to the staff reports and administration and management services.
That will be me, Tony Slagle, Deputy Executive Director. So I just want to talk about a couple of things. We, at the November commission meeting, the commission chair appointed a committee to interview prospective candidates for the inspector committee vacancies upcoming. Commissioner Arriaga as the liaison was appointed, as well as Fred Wilcox and Larry Foster as two other people who will be on that committee to do interviews. Right now, we have a deadline of December 31st for applications to come in, and then once we get the applications in, the committee will determine who they'll interview, and we'll set up interviews sometime in January. The recommendation needs to go before the chair at the February commission meeting. So anybody who's interested in applying, please send me, or you can send it to general counsel or send it directly to me, a cover letter and a resume and a letter, just something explaining your interest in being on the committee. And if anyone knows any public members, we're having a bit of a difficult time finding anyone who's willing to serve in a public capacity. So if anyone knows anybody who would be good, let us know and have them do the same process. So that's that. Any questions about that?
I have a question.
Yes,
On the
ma'am.
public members, what are the limitations? Can they not be involved in, or what is a conflict?
They can't be involved in anything on the inspector industry side, including working for a company. We've had some people who aren't inspectors but have been interested who actually work for an inspection company. It's just too close to what their role is, which is to, represent the public, and being too close to the industry at that point. And they can't, I believe it, I'll have to look and see, but I believe it's any, I think that's it, is the inspector.
Can't have a real estate license either.
No, that's any, and so you're right, it's any real estate transactional relation,
Okay.
so. Okay, couple other things. We had our first public sunset meeting earlier in November. It was the week of the commission meeting. Gave public testimony. I don't know if everyone here was able to watch that, but there were some questions asked about, specifically about inspectors, and a couple of the members of the Sunset Commission asked for some further information about whether or not there was a conflict in having inspectors regulated by the commission as it's currently made up. And the Sunset Commission staff is gathering information to give to them. I think the deadline was last week. They were going to provide them with some information about what they determined based on their further looking into the issue, whether there was a conflict or not. So the next Sunset Commission meeting is December 13th, which is when they will vote on the recommendations for Trek and the board. They can do one of three things. They can either approve the recommendation or vote to approve the recommendations as they were presented in the staff report. They can amend them, or they can choose not to do anything, like to dismiss them and say they're not necessary. So that'll happen on December 13th, I believe, which is a Thursday. Any questions about that?
Will we be able to view that?
Yes, ma'am. It is broadcast live, and I will make sure that everyone on the we put a notice on our website, but I'll make sure everyone on the committee also gets a link to that as well.
Does that not,
Good,
the
thank you.
final results come out on the 14th, is that not correct?
So they'll vote. Do I have the date wrong? It's
It's the 13th.
It's December 13th,
Right.
Tony?
Yes, that's right. That's what I said. So anyway, they will vote on the recommendations from the staff at that point. And then what the next step is they'll make a final report. Sunset Commission will do a final report, and then there'll be legislation based on that moving forward. So
Does that
So-
mean, so when they make recommendations for legislation, that means that the appropriate sections would start making those changes?
Yeah,
Or
so-
legislation just happens?
No. So the final report will come out from the Sunset Commission, and then someone on the commission, likely the chair or the vice chair, will draft a bill based on those recommendations that they voted on, based on the final report, that this is what the changes they want to see, if there's any legislative action that's needed. And they'll file a bill that has those changes in place. And then it goes through the regular process, where it'll go through committee hearings, there's chances for amendments, it'll go through the second house, whichever house it
But it
initiated.
all happens above
The commission.
the
Yes,
commission
yes, sir.
here?
Yes, sir.
Tony, it's Mark Moore, do you want to mention the difference between the statutory and the management recommendations? Since that has a slightly different process, the management recommendations.
Well, yeah, the management, okay, thanks, Mark. So there are two different types of recommendations typically in the final report. There's statutory recommendations where they need a legislative change, and then there's management recommendations, which are things we can do
Within
internal.
the
So
already
rules,
set-
or even
yeah.
administrative policies and procedures we can change. So,
Okay. Well, I mean, it kind of a question, because we kind of know as inspectors, some of the things they keyed on was our education. So is it in our interest to be working towards those?
I think so.
If we think that
I think so.
bill is just going to be introduced above us and the changes will be made without any of our input?
I don't know if that particular recommendation is something that's going to be statutory. I think they directed the committee and the agency to look at ways to
Okay.
address the education issues.
So it would start at this level and
Yes,
work
sir.
their way up with the backing of the sunset recommendation?
Yes, sir.
Okay.
But it was also noted that the inspector committee was already beginning to work on some of those,
Right.
some of those
Right.
education issues that they brought up. We were already,
Right.
we're already in the process.
There were a
That
couple of
was-
things the
that was taken
Sunset
into
report
consideration.
mentioned that the agency had already been moving on some of them already, so. And inspectors one of them. So, if there's not any questions, the last thing I wanted to mention is this week we are having meetings with Pearson View staff and internal and staff here, as well as subject matter experts, i.e. inspectors, to review the examination questions. So that's that tomorrow?
Yes.
Yeah, so it's tomorrow. So,
And Tony, this is Carrie. Can you hear me?
yes, ma'am.
Okay. I just wanted to clarify the rule for public members is they cannot be registered, certified, or licensed by an occupational or regulatory agency in the real estate industry.
Thank you, Carrie.
So that's a little broader. Mhm.
Thank you. But we also have determined, at least the past interview committees have determined that having someone employed with an inspection group is probably not good either.
Yes.
There's a
Right.
conflict, a potential conflict there. So, thank you, Carrie.
Mhm.
That is all I have, unless anyone has any questions about anything else.
Any questions? Okay. So we're going to move on to standards and enforcement.
Mark Moore, Standards Enforcement Services. I was just going to mention a couple things on the report and then give you just some year-end numbers that you might not be aware of. We had 3 agreed orders and 3 advisory letters, so somewhat of a typical month, or typical period since the last inspector committee meeting. I did want to mention just one thing, the advisory letter at the bottom of the page on the screen, 184084, did not verify accuracy of information reported on inspector report. It was basically a typo in the report that they should have caught, which actually led to a complaint, because they had said they didn't inspect the air conditioning equipment because it was less than 70 degrees outside, and they should have said 60 degrees. So it was just a typo, and we verified that it was cold that day. So the inspector was correct. They put the wrong information, and that caused some issues. So we did advise you got to be a little more careful to that, because that actually led to a complaint and an investigation on that. So it was minor enough to justify an advisory letter. The other thing I wanted to mention was just some trends on the last 4 years, just because you don't get that a lot. We have a monthly case status report that we do talk about at the commission meeting, and we do look at the row inspectors' complaints. And there's a huge increase in broker sales agents and a massive increase in background history checks on the broker sales. We didn't really see the fluctuation on the inspector side. I looked at the last 4 years, In 2015, we had 67 total complaints. In 2016, there was a huge bump to 98, almost 100 complaints. And 2017, there was 81 total complaints. And in 2018, the most recent fiscal year, there were 84 complaints. So it's been pretty steady on the inspector side in terms of mostly consumer, almost all consumer complaints.
84 seems pretty good to me. I mean, compared to how many inspections we do in a year as an industry. I mean, that to me makes it seem like we're doing something right as far as education. I know everybody hits education pretty hard, but we've got to be doing something right, either that or the reports or.
And probably well over half of those are self-inflicted, like wrong
Like,
forms and
yeah,
stuff.
exactly, DBAs, or, you know, if those are the.
Not actual poor inspecting, a lot of it's
Right.
administrative.
And I'm sure that when you get some, they're big, you know, I'm sure there's those, but it's nice to see that, to me, 84 is a good number considering the real estate in Texas, I think.
Yeah, you think
That's
the
my
market is,
opinion.
there's been a lot more transactions,
Yeah.
so that's slightly surprising.
Yeah.
There's
so-
more
so I
inspectors and
I
more-
think we should be proud of that number.
Well, that's just the number of complaints, not the ones that are actually justified.
But it's a gauge, whether, you know, he has data that he can compare to, and so, you know, I think that's something that we should take as a positive, actually. It's never gonna be zero, so. Alrighty.
I have a question on the next page of the discipline. So is this Truck's expectation, I mean, this might not pertain to this discipline, but they in the complaint, they didn't deliver the report in 3 days. Does Truck have expectation of that delivery if funds aren't received? Just wanted to get clarification on that.
That's a good point.
It's always said,
I know.
whether you donate it or get paid, yeah.
If you
Yeah.
perform the inspection, you have to
Yeah.
deliver it, whether you get paid or not. It's an issue we have to deal with. Sometimes people don't like it, but if you perform it, you have to deliver it.
Yeah, that's been talked about a few times here. It's kind of unfair, but it's kind of.
I wanted to get clarification on
Yeah.
that.
Sorry, that's.
Yes, sir.
I know a lot of people.
Can you identify yourself, please?
Oh, I'm sorry. Shannon Gatewood, that should include electronic delivery, whether they can open it or not, because they haven't paid.
Yes.
Well, wait a minute.
You can
I send
deliver it,
to
yeah, our
Inspector
software.
Support Network.
It's not delivered until they can open it. I think that's a mis.
They have it in their email box, it's been delivered. I'm just clarifying.
But you're saying they can't open it until they pay,
Right.
Correct.
and I don't think that constitutes delivery
Delivery is when they can read
when
it.
they read it.
Wow, I didn't
That's
even
just-
know that. I always thought as long
It's
as
a can
it's
of
been
worms.
That's just
emailed to
unfair.
them.
But
If they
like,
don't pay for it, why should they
We
get a
deal with
product
that.
they don't pay for?
well, we know, do what?
Why should they get a product they don't pay for?
Exactly.
HEB doesn't let me walk out the door with bread I don't pay for. Why in the
pay-
world?
There's-
would we
There's
do
a,
something
I'm sorry,
that-
there's a section in the rule, I can't cite it right now, but I recall that it says unless otherwise agreed in writing.
Okay, which would be our inspection agreement that says that they agree to pay for this report, right?
So depends on what the language, if they agree to something other than the 3 days in writing, then that's something we would consider when determining
Right.
whether there was or was not a violation.
So your verbiage would have to specifically state payment to be received before the 3-day timer would start.
Be motivated to collect before you go.
Yeah.
I know Guido.
Okay. All right, well, that's something interesting, Tony, to discuss if we
I
could
think
at
we've
some
had
other
that
time for a
previously,
future
though, in the
agenda
past.
item. I just want
No,
to,
no,
I just never.
I'll make sure to make a
I'm
note of
not
that, that
trying
we'll.
to be argumentative, I just did
No, I
not
got
know
it.
that
I think
we
it's
were
valid.
We've
required
discussed
to
it.
deliver, I knew the 3 days,
Yeah, it's.
but not if they hadn't paid us.
No, whether they pay or not, that's been the policy.
If you do it.
Interpretation.
And that was motive to make sure you get it paid for.
Well, I mean, it's a good question. Why don't we bring that up as a future agenda?
Yeah, that's
Yeah,
what I'm
he's
doing.
right.
I'm making a note that we're gonna
Right?
add
It's in
that.
the statute. There's nothing
It's
we
in
can
the
do
rule.
about that.
The rule.
In the rule.
He was right, though. I just want to make sure we're, I
Yeah,
don't want to
we
get too
just-
far.
No,
away.
no, I just wanted to make sure we could put that in.
Yeah, I got it noted as a
Thank
future
you.
agenda item.
The discussion could probably elaborate on what you would have to put in your agreement to go around. I mean, not to go around it, but like, when I do an inspection, maybe it's really big, I'll put in the agreement that you may not get this for 4 days. and they sign off on it, that would be an exception to the 3 days, because we both agreed you're not gonna get it for 4 days, because it's taking me that much work.
I
Well,
don't want us
we'll
getting
talk
involved in
about
the
that.
agreement between the inspector and the
Well,
client,
Right,
but.
well,
right. I'm just
that's
saying,
what the
let's
statute
just
says.
discuss- I'd like to discuss
Yeah.
this, particularly just so that there is,
Yeah.
clarification, because honestly, for me, it's the first time I heard that.
Oh.
of that. I knew the 3 days, but not the payment.
It's come up at least 3 or 4 times since I've been here.
Yeah, but you've been here long.
Yeah, some of us are
On
new.
on here, at this table, it's come up on the agenda multiple times.
I don't remember.
I don't remember my history.
Yeah. Okay.
You're just
so-
getting old like
Go ahead.
So Mark, are you through or? Okay. Thank you. Education and licensing services, Glenn?
The first report you've got there is that L1A report, and that's the report that provides us with, Gwen Jackson, Director of Education and Licensing Services. And this report provides us with the fiscal year-to-date comparisons of applications received, licenses issued, as well as our renewal activity. And as you can see there, for this year-to-date so far, and that's from September until the end of August, we had received 84 original applications, which is 109 less than we received at this time a year ago, for a 56.4% decrease in number of applications received. From there, I'll drop down to the number of licenses issued from original applications. We've issued 166, which is a 30.7% increase over that a
Can I
year
ask,
ago.
can I ask a quick question on that? How is it that we have only 70 applications received, but 148 licenses given from original applications?
Because this is a time span of 3 months, September, October, September for 2 months, September and October.
Right.
And we've still got individuals who are in the application process, whose applications have been approved, who are taking exams, waiting to get their insurance, and waiting to get their background history checked.
It's not apples to
Yeah,
apples.
so it's not,
Gotcha.
it's not apples to apples.
Because you have 12 months from the application to
yes.
get your license. So some of these could be applications put in.
From a year ago,
Year
or
ago.
almost. a
It
year
seems like a
ago.
big spread, so that's why I was wondering.
Okay. And then moving down to renewal activity, 273 so far have renewed their licenses, or 71% of those who were eligible to renew have done so. If there are no questions,
No. Any
further
questions?
questions on this one? We'll move to the L2 report. And in the far right column, on about middle of the page, you'll see the total number of inspectors that we've got. At the end of August, we had a total of 4,131, which is 129 more than we had a year ago. Any questions on this
Who
report?
does have any questions? Glenn?
Then the next report is on our examination activity. And again, this is for 2 months, month of September and October. And as you can see, on the area to your far right is for this year, 2018. And the comparisons for the same time period in 2017 are on the left side there. But you see that so far, 10 real estate inspectors are taking the exam for a first attempt pass rate of 0%. So none of them pass the exam. Then you've got the professional inspectors, 149 so far have taken the exam. And there is a 35.3% first attempt pass rate. And
That'll
I
change
believe-
once we evaluate the test.
Sir?
Well, evaluate the exam, but also the courses.
Courses.
You know, and taking a look at the qualifying courses that are required to obtain a license.
If you recall, we lowered the pass rate,
From what, 80 to 70, right?
and we were about 48, 50% pass rate at that time. We've lowered it now, and the pass rate keeps falling, which tells me it's an education problem.
Well, it also makes me, I think the exam may be a part of that too. I mean, I hear a lot of complaints about the exam itself.
I do too, but I've taken the national exam myself, and granted, we're not the best candidate for it, but I went through it in an hour and a half and made 97 or 98 on it.
Okay.
I know I'd asked before if we could get data on pass rates from other states. And I know I think you had said that you thought we could.
And I think during one of our meetings, I provided data on the national pass rate, the pass rate
I know-
across
I know there was
across the country, yes,
as a whole,
as a whole.
but not for each state. So what I was trying to see if they could provide one by state, because we could compare that to the training they provide at that state. Because the average training is like 75 hours or so.
Right.
And
much fewer.
if the pass rate is even better than ours at 300 and, 90-something, 94 hours, that's a very obvious,
Are
elephant
there
in the
any
room there.
specific states?
The ones that require
All
training.
of the ones that require.
Yeah, and it might be easier for them to just spit out by state, rather than try to filter that by the ones that require training or have licensing. But if they just had it by state, because there are a lot of states that don't have licensing that have training requirements. Maybe it's a registration.
The one thing that we don't see on that, and I think I've asked this before, is the pass rate. We've got two modules. We've got the state module and the national module. Do we
Yes.
have the breakout on which is which as far as pass rate?
Is that
Yes.
failing either one of them?
You have to pass both.
So if you fail either one, it shows up as
It's
a
a
fail.
fail.
Right.
But that's what we had asked before, was getting a breakdown
On
of
whether it's the
state
Texas
versus
module
national.
or the national module or
And is
both.
that something that, I believe you guys asked for that through the education subcommittee? Was that right? Or was it
No,
this committee?
It was here.
I
Well,
think it was here.
if you guys
But
are meeting with them tomorrow, and that might be on the list.
we'll do that, but my concern is, I'm told by a lot of people taking the exam, they failed the state module. There's absolutely no excuse for failing the Texas module.
I agree with that. Everybody I talk to fails the national, not the state.
Well, I'm hearing just the opposite.
Okay.
But yeah, so the question, I guess, that data could provide, because they would only, I guess they could provide the state-by-state pass rate for the national. And do you have the ability to break down of those failing, how many of those are failing the state and how many are failing the national module? Because if 149 people took the exam and only 42 passed, of that 107, how many of those were state failings and how many were national failings?
Yes, I can get that information.
And even going further, on the national exam failure, could they tell us what areas they're failing in?
You can get that average on their website, but it doesn't.
Not on by state.
No, you can't, it's just like she had, you can get a nationwide average.
I can get a nationwide average. I can request and see if they can provide us with a state by state.
Yeah, the nationwide average is available on their website.
Yeah.
Right.
But it doesn't really put any value to, the kinds of training.
And I know we've provided
That would
that
be very,
before.
yeah,
The,
that would be really helpful to see trends.
The breakdown of what each state requires as
Right,
license.
and we have those.
We have those, and I know we've done that before, where we show state by state whether they're,
Yeah.
if they require how many
And-
inspections they require, how many course hours, all of that stuff. I
know, I've got that one, it's a couple years old.
Yeah.
And a couple of states have gone up since then. It was like this one, yeah, by state. But the only thing missing on the, we have the training that they require, the only thing missing was Okay, does that training give them a better passing rate than we
Right,
have?
right.
I mean, because we've always, I mean, our training has gone up over the years.
Mm-hmm.
The answer to poor pass rate was just more training. Well, I think the proof in that would be showing that all these other states are between 60 and 90 hours, and they all have pass rates better than ours for the national exam. Something's wrong.
Well, the question becomes, are they targeting the areas that we're weak in? And so that might give us an
That's
idea.
one of the pages.
When is that, with Pearson View coming in tomorrow, is that who you can ask directly, or is there somebody else that you have to go to?
Typically, I'd go to NAHI. I'd go to their website. I'd contact them to get that
Okay,
information.
so the people that are coming tomorrow to go over.
They're strictly looking at the state
the state.
portion.
Oh, okay,
Texas
okay.
Yes, that's the key. That's where we want to go. See, fast track is where I'm at.
Is there any other questions for Gwen? Barbara, any other questions?
No, I appreciate the feedback, though. I think that was Steve that made those suggestions. That would really help us with trends and seeing areas where we have gaps.
Well, and Tony just noticed, I mean, made the observation, which I had, was the states that have less classroom training have more hands-on
Yeah.
training. And
Yeah.
if that equates to better scores, then,
Then we need to look at it.
well, and our fast track program eliminates the hands-on. So it
Right.
kind of defeats where we're
Well, no,
going.
there's a requirement that you have some.
Some.
Ride-alongs, which we
Yeah.
put in a few years ago.
Right.
Well, yes, but it eliminates the apprentice training, which most of these is apprenticing. They have different names for it, but most of the other states that license, majority of them do have apprenticing, and some of them are quite extensive.
Well, let's keep in mind, the fast track program was a legislative change, was it not? I mean,
Yeah, but it was a legislative change,
statutory?
but it was before I was here, before my understanding, it was a legislative change based on the fact that there was there were two hurdles. One is we're a big state, so there's always concern about making sure that everyone gets adequate experience. And the other thing was that there was a lot of talk about people not wanting to train their competition. So there's this, that's also something that I think the ride-along takes a little bit of those concerns away. But
And we don't have any data that says that all of the people that are failing the test are fast track. I mean,
No.
we don't have anything
No.
that says that. So I always think that just targeting the fast track program isn't necessarily the answer for.
And
I know
why-
virtually all the inspections that we get involved in evaluating are fast track.
As far as.
And as far as, there's not many,
ride-alongs?
well,
Or-
but there's not any apprentice inspectors coming up. So the bulk of everything you're seeing is fast track,
but to
95+%.
Not actually going to the classroom. You're saying that, okay. I didn't realize that we had that large of a percentage of education that's on the fast track. Okay.
Well, given the choice, you want to work under somebody else and work for them, or you want to be completely and totally on your own? Almost everybody's going to go right on their own and do it from.
No, they're gonna go get their license and then call one of us and ask us to train them.
Well.
But I think
But they're passing their test to get their license.
Yeah, 35%.
They can do a multiple choice test. That's right.
Yeah, I thought you started to say something. I'm sorry.
Go ahead. Jump right in there. The problem seems to be taking the information you learn in the academic class and applying it in the field, and we don't have a good way of requiring that. I mean, you can do hands-on or ride-along, but there's no, like a probationary period of doing inspections and actually having them evaluated.
Right.
I've got two guys just came out of class, and they still haven't written a report, and they're waiting on the authorization to go take their professional exam. and it's a challenge.
What I was going to say is I think that, to the chair's point, it's not necessarily the right conclusion to dismiss all of fast track stuff, because there's plenty of inspectors out there that do a good job, that were trained that way. It's just trying to find out, in doing this research, I think will provide some information about that in terms of where we need to be focusing on in terms of the education arena, on that versus the experience part of it as well.
And there was part of Sunset staff's review was they felt like we had some redundancies, right, in our education.
Well,
So-
there are several courses that do you take more than once.
Right, and so, I don't know if,
We've already been working on
if
that.
there's a way to, so that's the part we were already working on, but I just wonder, obviously redundancies aren't helping the pass rate either, so
Well,
if they're not
yeah.
memorizing or it's
I
just
mean,
not.
it gives the appearance that if you go the fast track to professional, that you would take the SOP, ethics, and report writing 4 times.
Right.
And half of the infractions are report writing problems, so maybe it's not working.
Okay, so any future agenda item on any of this that we want to add as far as
Well,
a future discussion?
I think
this
that
at all,
the education subcommittee is going to be meeting on that, and then they can bring forward any recommendations. So in terms of if there's any recommendations that come forth, that'll be provided to the chair to determine whether or not it's going to be on the next agenda.
Okay, so this will go straight to the education.
And for me, for clarification, in terms of the information that you're requesting, should I have that available for the subcommittee?
That'd be
or
great.
for the?
If we could have it, yes, to kind of
Yes,
formulate
it'd be helpful.
how we're moving forward on our recommendations.
Yeah, and then anything that the subcommittee brings back to the full committee, it can include that information if they.
Which gives you about 2 weeks, if you can
Oh, bless
possibly
her.
get it in
No
there.
pressure.
Christmas is
Hopefully you're
coming,
not on
Gwen.
vacation.
I'll be back. You'll be working while they.
The
I'll
sloth
be
doesn't-
working
the
while I'm
sloth
on
doesn't get
vacation.
him.
Yeah.
Well, then the final report you've got there is the L4 report, and that's, this report is on the instructor distribution. The inspectors are on the bottom portion of this page, and there you can see the number of approved instructors that we have for each category.
Any questions from the committee for Gwen on this report? Okay. And that's it?
Can I add one
Yes.
thing I forgot to add in my AMS report?
Sure.
Just want to remind everybody that next month, or not next month, next meeting, the February meeting, is the one where inspectors can get credit for attending. So that's also the meeting typically where the committee elects their officers. So just wanted to let everybody know. I forgot to mention that in my AMS report. Thank you.
Thank you. I forgot about it. Start campaign. All right. So is that all, Glenn?
Yes.
Thank you very much. Okay, so agenda item 7, discussion and possible action regarding recommendations from the working group regarding contractual limitations of liability. And this is in regards to Lee, Warren, myself, Tony Seigel, and Carrie Lewis all had a meeting to discuss the contractual limitations of liability, and Carrie Lewis is going to give a report. Am I correct?
Yes.
On this?
Yes, ma'am.
Yeah,
So
yeah.
Carrie, go ahead whenever you're ready.
Okay, all right. So, yeah, as the chair stated, she and Lee Warren, Tony, and I met on November 19th. And prior to that meeting, I did some research, as I told everybody I was going to do, on the inspector insurance statute, as well as other statutes that required general liability or E&O insurance for similar type industries, and I also spoke with several insurance agencies. In addition, I spoke with several regulators of various license types regarding their interpretation of their statutory insurance requirements. In particular, I focused on the two items that we've been talking about, defenses and limits and contractual limitations for insurance. My goal was to explore more of the literal language of the inspector statute, and you've heard general counsel's opinion and staff opinion on the literal interpretation, but my goal was to go beyond that to ensure that we were not recommending prohibition of something that commonly occurs in the insurance industry or among other license holders that have similar insurance requirements. So I shared my research with the working group. I'm going to share that research with y'all, and then I'll tell you sort of where the working group ended up. So as we discussed at the last inspector meeting, and by the way, as was supported by the commission at their November meeting, defense within limits will be supported for statutory inspector policies. Based on my research, I think TREC could even allow for such provisions in a policy if the legislature doesn't change the existing language. And here's why. My discussions with other regulators and insurance companies revealed that these provisions are fairly common in many types of general liability and E&O insurance policies. And the regulators that I spoke with do not object to having these in a policy. I also found out that these type of defense within limits are not regularly used, since most claims against contractor type license holders settle without the insurance company having to hire an attorney or go to court. They have, just like you have with personal injury, right? They have schedules where they say this type of error or this type of liability loss is worth X amount. They have their, I forget what they call them, their charts, actuarial charts for all kinds of types of insurance liability or damages. And so they generally can settle fairly regularly. And we talked about, you've got your deductibles as well. But to me, this means, all told, that defense within limits is an accepted part of a liability insurance policy requirement and not necessarily a great erosion of consumer protection, especially since most claims against inspectors can be paid out of the policy even if defense within limits is exercised, and the inspector remains liable to the consumer for amounts awarded over the policy limits. And we brought that to the commission as a recommendation, has supported it. If the legislature wants to change it, that's fine. But I feel comfortable now, having done this research, that we could also do something by rule, and I think that's within our jurisdiction. In fact, the AG's office even gave us a letter saying we can interpret specifics about the insurance policy. So I'm comfortable with that, and that was kind of just me double checking what we had already decided. However, when it comes to contractual limitation on statutory amounts, my conversation and research with insurance agent and other regulatories showed that it's not a common or acceptable practice. I looked specifically at and spoke with TDLR, and the license types that are required to have liability insurance there are your HVAC contractors and your elevator and escalator contractors. And the plumbing board is another one where master plumbers have to have general liability insurance. So I spoke with both of them in a little more detail. Both TDLR and the plumbing board stated that they are not aware of any of their license holders that have provisions in their contracts with consumers that limit the liability below what is statutorily required. They both regulators stated that they would take action against license holders who have such provisions. I also talked with several insurance companies, and I spoke with those who sold general liability and E&O insurance policies. In particular, I was looking on what was going on with these other types of license holders. And they stated that while insurance companies may require a contract between the insured and a consumer that sets out the scope of the work. They did not require contractual limitation of liability to fees charged for service. So from what I researched, putting in such a limitation is not commonplace in their experience. It's not a common practice. In addition, ironically this month, the TREC enforcement staff received an email from a consumer who said, what can I do? This inspector has made an apparent error on their inspection, and we're trying to work with them to get some settlement, and they're saying we're limited to the contractual language, which limits it to the service fee. And this wasn't a complaint, but the enforcement division said these types of questions all the time, or not all the time, but not infrequently. Let me put it that way. And since it's just a question, obviously what TREC does is that if you want to file a complaint, you can file a complaint. We can investigate it, or we can't. You contract to get an attorney with your standard language there. To date, we haven't got a complaint on it, but obviously we could. So the working group discussed the rationale again for why inspectors include such language, and both Mr. Rose and Mr. Warren reiterated that it's an attempt to limit exposure due to frivolous claims. However, to me, this email illustrates that there is some danger that inspectors use the contractual limitation language to get out of any responsibility for any errors. So, given all that as background and research of what happened before our meeting, the working group determined that given the statutory language, chapter
Carrie.
inspector using contractual language. Can you hear me?
No, Carrie, you broke up there.
Hello?
Hello. You broke up right when you said, based on that research, the working group determined, and then everything got garbled after that.
Okay, my phone service, probably a big wind blew through. Is it better now?
Yes, it is. Thank you.
Okay, let me try. So what the working group determined was that given the statutory language in 1102, TREC could not condone an inspector using contractual language that limits an inspector's statutory financial obligation. The working group did, however, note that contractually limiting other types of liability not required by statute is okay. So we talked a little about what can we do to sort of balance the inspector's need against frivolous lawsuits and or claims and the contractual obligation that the statutory obligation the legislature has put in place. And what we thought was that clarification regarding the contractual bill could be addressed by rule. So that's one way we could address what TREC expects. Am I still there?
Yeah, you
Breaking
garbled
up
up.
again?
You garbled up when you said what could be clarified by rule.
Okay.
Is this like an attorney trick?
Well,
Yeah.
okay. Just keep telling me, Tony, when I'm losing reception. Like
Okay.
I said, the phone, I'm using the VoIP phone and it's inconsistent.
Okay.
So what I think, and the working group thinks, could be clarified by rule is both the defenses and limits and the contractual limitation of liability. And not dictating necessarily what can or cannot be in a contract, but just stating that you can't limit the liability set by statute in your contract. Other things can contractually be limited. Other types of liability can be limited, but we would limit it very strictly to what the statute requires, that couldn't be limited. Unless, of course, the statute changed. I'll get to that in a minute. In addition, the working group recommends creating a separate inspector consumer notice to better educate the consumer up front. You know, explain the nature of a home inspection. It's a visual inspection as of the day of the inspection. It is not a warranty of the condition of the home. And I think we need to do a better job, both associations and TREC, of informing consumers of that, educating them of that. And also providing notice of the insurance requirement in the same notice. So basically, not doing the IADS per se, but taking the consumer protection notice that is used for both inspectors and real estate license holders and doing one specific to inspectors that has more education and sets out the rights that consumers need to know about. Now, we know legislative session is coming up, so the working group recommends that we can begin working on these items, but not take any action on any of these items until after the close of session, in case the legislature takes action related to any of these issues. So the last thing I'll say is, while TREC does consumers to recommend
Carrie, you broke
that
up again
statute,
there.
Yeah?
You broke up
Okay.
again there when you
So-
said
The
very last thing you said.
Okay, every time I get to something really good,
Yeah, I know.
it breaks up, so it must be am I now?
You broke
Hear
up.
me?
You-
Can you hear me now?
Yeah, I can hear you now. Gotcha.
Okay. Maybe I need to speak more slowly. So, although TREC and the working group does not feel that it's appropriate to support limiting the financial liability required by statute, because that's not in the best interest of the consumer, the legislature could make a change based on other input from, say, trade associations, if they felt that that was something they needed. If the statute changed, then we, of course, will follow the statute. So the working group and working group members, feel free to chime in at this point, feels that these are some ways to help mitigate the effect of the financial insurance requirement in the legislation currently without overstepping our obligation to protect the consumer. And that we should start working towards it, but wait and see what comes out of the legislative session before any recommendations are brought forward to the full commission. So that's my report. If anybody wants to add anything from the working group,
So my
please go ahead.
interpretation of what you just said, Carrie, is that we don't do anything at
Well-
this point.
Well, we don't do anything right now.
But
There's, there,
We're kind of in a holding pattern until the legislature meets.
but the thought process is if, unless there's some sweeping change that we don't know about yet, if it stays as it is, there are basically 2 points in the working group. The defense within limits, which we've all kind of come to consensus, yes, it's allowed within that, so everybody's good in that respect. The other one was the limitation of liability. And the concerns that staff had was that certain inspectors may be limiting, like the complaint, or not the question, not the complaint that they got, about limiting to the cost of the inspection. But from an inspection standpoint, we want to be able to try to eliminate a lot of those frivolous deals that come up. And that's what a lot of that, gets rid of. So as a way to kind of compromise and find the best of both of those, creating an agreement. Similar on the real estate side, you have to give an information about brokerage services to every client, the first substantive contact, which basically lays out, this is what an agent does, this is how they get paid, this is what their responsibilities are. Doing that on the inspector side at the first substantive contact, possibly, for your inspection clients. When you book the inspection, wherever the case may be, you can send in an email, you can send PDF out via text. If you just did it by phone, your inspector support network can send it out, whatever the case may be. A lot of it is going to be information that's still in the OPI, but people don't see the OPI until they get the report, so by then it's too late. So this is giving them that information, educating them as to what the purpose of the inspection is, what the limits of the inspection are, that, oh, by the way, the inspector, you can have an agreement with the inspector, but it can't limit the liability, go less than the statutory requirements.
We can limit other liability as far as what we're liable for, what we're not, as long as it does not violate the statutory requirements of what we're required to have.
And she's looking at, was the thought that Trick would create an independent form for inspectors?
A separate consumer notice.
That we could just link in our inspection agreement, like we do now?
Well, that's part of the discussion. We could link it as part of the inspection agreement, or we could do it like the IABS does at the first substantive contact. First phone call where they book it, depending on when the inspector sends the agreement, it may be the same time.
I see it sometimes, on an agent's email, they'll have a footer on the email that goes 5 more pages, and it's all of that stuff, just to say, yes, I'll be at the inspection, but their signature block, and then it'll have all that information you talked about is just a footer on every email they send out.
And there will be specific rules, because there are rules about whether you can put it in as a footer or not. But there will be specific rules on that. But the thought process is to have a separate consumer notice of, here's what an inspector's job is. Here's what the scope, based on the standards of what the inspection is here. And the inspector can have a separate agreement, but it cannot limit the liability inspector less than what the statutory requirements are.
So that could be a pretty lengthy, what an inspector does.
Well, I think, yeah, you don't want it to be something that someone's not going to look at.
You mean like the purchase contract?
Yeah, you want it to be like...
Got to be a page, no more than a page.
Yeah, just one page is all we're really looking at. Something a general overview of is the limited visual inspection of the property, blah, 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 blah.
And are y'all talking about implementing that in the near future, or wait for the legislature?
Wait for the legislature, because if they change it, then all that work will be
Okay,
absolutely pointless.
so we're really talking about not doing anything substantial right now.
Right.
Just working toward that direction.
Right.
Because you don't know what's going to happen to any of this stuff.
Right.
Regardless, clarification about the insurance requirements, clarification about the recovery fund, all of that stuff needs to be taken into account when you present some sort of consumer notice to the committee to vote on.
It was my understanding, and correct me if I'm wrong, that the commission, we went to the commission at the November meeting to allow defense within limits.
Yes.
And so that's a moot point at this.
Yeah.
Right.
Yeah. No, that's
The only
what
thing
Gary
that was
said.
still up was the question about our ability to limit our contract.
Right. Prior to the creation of that group, it was still,
Right.
it still hadn't been approved. So it was
Right.
on there, that we just wanted to clarify that everybody's on the same page for that particular
Yeah.
thing.
Hey, Carrie, on your research that you did, this is Doyle, by the way. Your research indicated that you compared several industries to the home inspection industry, but there's a stark difference that I want to point out. All those service industries are hands-on contractors doing physical work to buildings or structures, where we are not. We're more of a subjective, written interpretation of the standards of practice. So I can't see a comparison between those two.
Well, I looked at some others too. There's actually a chart that I don't have in front of me right now, but I did provide to the working group that had a whole bunch of different licenses that have requirements for insurance, and there was only one out of all of those. There was only one that allowed contractual limitation, and actually I didn't tell you about this, but that's fire systems, fire alarm systems,
Like sprinklers, I
and
think, right?
I think smoke detector installers, and a couple of it like that. Those are all with the fire marshal, and actually I talked to him as well. So some of those, again, you're right, are hand-on installers. But of the 3 types that the fire marshal regulates, only one has that exception. And I asked him, I said, why are they allowed to put in a contractual limitation of liability? Because I'm curious, and that was a legislative negotiated thing by the association to put that in. And his opinion was, and he was going to get back with me, and to date has not, and I've been out, so I haven't bugged him about it, but I'll do that this week. His opinion was it was not so much to limit liability below the insurance requirement. It was to allow them to put changes in their contract for when they have really big, some of these commercial systems for fire smoke alarms or sprinkler systems or any of those things can be millions of dollars, and they wanted to be able to limit their liability to a set amount, so they're not liable millions of dollars if there's.
Carrie, that sounds right
now,
on.
Is that it could be either way.
It seems to me that we should be looking
Pardon me?
at. It seems to me that we should be looking at industries that are more interpretation, like an attorney, for example. You know, the attorney interprets the law and advises their clients based on that. We're kind of in the same ballpark as that, and then there's probably several other industries
Right.
that are similar to ours and yours.
I understand what you're saying, and I agree. However, I don't think attorneys are required to have E&O insurance,
Yeah.
and neither are real estate folks. So all I was looking at are those that have statutory insurance requirements.
it's-
The fact that
That's what the-
home inspectors were thrown into that same requirement is something that happened at the legislative level.
Understood.
So that's what I'm saying. If the association can use that type of argument, which I'm not saying is a bad one, to convince the legislature that that's not needed anymore, you know, then that could change. Or to convince them that it's different than these other types of insurance requirements for these other types of hands-on contractors, you know, that's fine. But as it's written today, as it's in the statute today, all I had to compare it with were those that are required to have them. And some of these other ones that you mentioned, while most of them have them because it makes good business sense, they are not statutorily required to have it.
Understood. I would just suggest that if you're going to be presenting this to any legislative level based on staff's report or their research, that we really want to compare apples to apples, because we are an anomaly when it comes to that statutory requirement to carry this insurance. And if there are no other companies that do a similar service as we do out there, then I would prefer that be part of the presentation to the legislature if that's part of what you do.
Right. Now, that is not something that Trek does at all. We do not lobby. We do not make recommendations for these types of changes. We can act as a resource. And if at some point we're approached as a resource, I will make sure that if we're asked questions about it, to point out that difference. I have no problem doing that.
That's my only concern, is that we do address this from my argument standpoint.
My question, Carrie, and you may have said this, and maybe not, this is Brad. Did we look at structural pest control and their contractual liability?
Structural pest control does have it. I wasn't able to contact anybody, but they do also have a liability.
I know they're
they do have to
required.
have liability.
I know they're required to have liability, but
Yeah.
you know, is there a
Limited
limit of liability in their contract, or they're required to have a limitation?
If there's not one in their statute, whether there's one in their contract or not, I did not, like I said, I didn't get a hold of those folks in my research that I did for the meeting, but I can look into that.
I'd like to know
We're not
more.
going to be doing anything immediately.
Well, the reason I say that, a lot of people that do
I can-
just do WDI, they don't do any treatment, they just do WDI reports. That falls very similar to what we do, where they're just providing a service. And if they can
Okay.
limit their liability by contract.
The
Well,
the
and
problem with
support
that
our
is,
position.
the problem with that is there is no inspector license with TDA.
I understand
So
that.
if I've got a termite inspector license, I can also apply product 2, which becomes very dangerous, of putting toxic chemicals down on the property. So my liability is different from just the home inspector side.
You're paying for the liability of something you don't pay.
We're kind
That's
of
not the point.
We're
But I
kind
mean,
of
that's
going
what
off
happens.
on
Yeah.
a little bit of a tangent here. What we're talking about in the recommendation that the work group had was not to limit the liability of inspectors or limit the ability to have limits in your contract. That's not it. The only thing that we're talking about is having this notice that specifically states an inspector may have a limit of liability so long as it does not conflict with the statutory requirements.
I'm clear
That's
on
it.
that. I just wanted to point out that the comparisons on how we are an anomaly out there because of that specific requirement that our industry now has to carry. So anything that is any information that is brought to the legislature from the Texas Real Estate Commission, I just would prefer that that part be very well clearly stated, that we're not like the comparisons that came up in the research.
But track does not.
Sure.
I
Trade
recognize that.
information.
I know you don't, I know TREC does not lobby, but if the legislature were to want to find out what kind of research was available through the different departments, that research be brought forward in a fair manner.
Yeah.
When you say not doing
Understood.
anything for this session, how much time are we talking?
May, end of May.
End of
At
May?
least.
Unless there's a special session, but you know, it all depends. I mean, sunset complicates things to a certain extent in the sense that there's different, there's gonna be different bills out there than there normally would be dealing with the agency. But yeah, it's typically end of May.
But there's nothing that we know of that's being presented.
There's nothing filed currently dealing with inspectors, but there will be when sunset, likely, I shouldn't say there will be, likely when the sunset bill is filed, and then if there's any other side bills, you know, as Carrie said, trade associations can always go before legislators and ask them to do something. There may be other bills filed dealing specifically with this issue.
Okay.
But as far as the committee goes, right now, I don't think there's any action that we're gonna take right now. We're just gonna-
Continue doing things as we've been doing it.
Right, until the legislative session is over, and then we'll see what the committee, the next committee
Okay.
wants to do. and take this up. Correct, so this is a no action.
Right.
Yes. Okay, so I have two people. Thank you, Carrie, very much. We appreciate it.
Welcome.
We have two people that want to speak. Randall Needham, please.
Randall Needham Property
You have
Inspections.
3 minutes.
Okay. Limiting liability is done across the board in almost every industry. It's done for doctors. In fact, they passed a law to limit liability on doctors so they don't get sued for X over what they have. As far as the fire marshal stuff, having worked on commercial areas, they get you, by requiring you to have insurance that covers them, and you have to put them in the rider. So even though they may have that term that they're limiting it, it's taken care of by the insurance, by the requirement that the company has before you can even step on their property to do work. And so limiting our liability, we're not trying to get out of covering what's going on, but we're trying to limit what people are coming after us, again, for stuff that we shouldn't be having to address. And that's what I had a neighbor come in 6 months after he moved in and said, my AC went out, and the inspector should have told me it was going out. And I looked at him and I said, no, we can't determine that. He said, is there any recourse I have? I said, no. He does the inspection as the date and time of the inspection. And so there's a lot of miscommunication. Don't know if it's miscommunication, but it's a lot of misunderstanding from the client's aspect as to what we actually do. And it's all out there in writing already. It's in the preambles of all the stuff we do about what limit of our scope. It's visual, and they still don't catch all that.
Which is specifically why we talked about creating this form, is so that, because when you see the preamble, the inspection's already done and it's the report. So by having this form that we're proposing, it's ahead of time. So they'll know that ahead of time, so it hopefully will eliminate some of that. Will it eliminate all of it? Absolutely not, because there are always people that just won't read it. But at least we can show that we're making the effort. Hey, here you go, here's the information. So if you just don't want the inspection, fine. But right now, as it stands, because it's in the preamble, by the time you see it, it's too late.
I just can't see another piece of paper solving this problem. I just personally, I don't see it.
I don't know that it solves the problem, but maybe
That's how I
it's
see it.
part of it saying that at least I gave you the information, whether you read it, whether you did something with it, whether you
I
know,
agree with
if
that.
you agreed and signed it and sent it back. That at least is your argument to say, I gave you all of this up front. I'm sorry if you misunderstood that this is not something we cover.
Was-
But maybe that's one speed bump, so to speak, before they, somebody goes,
Was
over.
that part of the suggestion, was to have a signature line on it where it's signed and?
I would not recommend having a
notarized
signature line.
and-
I know they did
I
that
know,
originally with the
my amendment
IABS.
it is, so I don't know.
But getting somebody to sign it, I don't think that's the important part, is getting them to sign and get it back. I think the important part is
Delivery.
proving that you delivered the information to them, that they had the information. And that can be done in a number of different ways. Read receipts on an email, text, read receipts on a text, any number of ways. But you start asking people to sign it and send it back, it's creating a whole different boat, which is why I believe the IABS doesn't have to be signed by the consumer anymore. It just has to be proven that it was delivered. So that's what we're referring to. And I think, like you said, it provides an extra layer of protection. And I think it's the best comprehensible solution to a number of different issues from our side, from Trek's side, and from the consumer side, it's not going to fix, but
Why
I
don't we
think
just put this back on the realtors to do for us?
Let's not go there.
But I think that it does meet the checkbox for what the committee is tasked to do, which is we're supposed to help the consumer understand what they're buying and to protect them against any inspector that wants to somehow get out of their duty as after they perform the inspection. And I believe that this is kind of an easy way to do it. And you already send them, if you're already sending them an agreement that you want them to sign, then this is an attachment to their email that they don't have to sign, but if they sign the agreement, they got this.
It also covers the inspectors that don't have an agreement that they sign.
Is there an initial draft of the verbiage?
Not yet.
No, we haven't gotten to that point yet. It was just a
But that's the
recommendation.
other thing, because not every inspector sends an agreement out and makes them sign it before.
Right.
This will require that everybody, that consumer, regardless of the inspector and what their personal company policies are, that consumer is going to get that information before they pay for that.
I see ways of incorporating this into automated systems too, like I use, that would
Absolutely.
be easy, so.
Yeah,
Absolutely.
mine's the same way, sure, as with delivery. And like Steve said, if it's an attachment similar to the way realtors attach
We'll look at-
some of their, there's ways to
We'll
do
look
it.
at rules, because there's
Yeah.
rules on how you
But
put it in
nothing's
footers
been
and stuff
written
like
yet.
that,
It's,
but you can have a PDF on your phone and literally after you get off the phone and text them the PDF. So it isn't the inspector isn't burdened with an extra cost or a whole lot of logistical junk.
Gotcha. Thank you.
So this isn't written in stone, this is something that it was part of the working group discussion, and it's an idea to take us to the next step, to help out with any miscommunication or lack of communication that consumers may feel that they need to understand what they're buying when they get a home inspection. Okay, Mike Cochran, 3 minutes.
Nothing is wrong. It's 3.5 for you.
Mike Gothran on behalf of Capria. That probably wasn't very professional, but I appreciate that. In regards to this, Carrie, it sounds like you did a lot of work on this, and I wanted to thank you. I think we would echo Doyle's concern about apples to apples, and one of them would be Fred Buckjus, who's a plumber, licensed plumber, said that plumbers are not required to carry any policy. So apples to apples is a big deal. Also, I noticed that this report was not, or the recommendations coming from the working group was not part of the materials. And since you alluded to asking for the some input or at least review from the trade associations, which I appreciate, I wonder if we could have these recommendations from the working group reduced to writing and delivered. That would be a request.
Okay.
Let me just take it. All right, any other discussion on this topic from the committee? So now we move on to agenda item 8, discussion of possible action regarding amendments to 22 TAC Chapter 535, Subchapter R, we proposed at the November 15th, 2018 commission meeting. And Tony, this was...
It's going to be me. I just did want to mention that I know that I believe the committee, everyone on the committee received Stan Harbuck's thing. He sent it out to everybody, but he also he's on the phone and he wanted to. Oh, sorry, I thought he emailed it to everybody on the committee. Is what it looked
Well,
like.
my email address was.
Well, I've got it. I'll pull it up electronically.
that's
But he
fine.
also asked to speak on this item as well once we get to that point where
Okay.
he's on the phone. So I just wanted to give a brief discussion about, or have a brief discussion about why this item is before you once again. Right before the commission meeting in November, we were looking at the language and realized there was a drafting error that would have, there was language that wasn't copied over from 535-218 that if it had been adopted the way it was proposed would have had a 40-hour ride-along only requiring one inspection for the entire 40 hours. So just missing the one inspection per 8 hours of credit, that 8 hours of credit not being carried over would have been a huge, I don't believe that was the committee's intent. When we brought that forward, it needed to be reproposed because that was a substantive change to the rule as currently proposed. That's the only change, if you look at the rule, the only change in the language from what you guys looked at and agreed to previously is this highlighted part that says, ride-along inspection course at a minimum consists of one full residential property inspection per 8 hours of course credit. So that means at least, which is what it was prior to this. So that's the only change. I will say that there was some extensive discussion at the commission meeting about the committee's initial recommendation to reduce the qualifying education ride-along from 10 to 2. In fact, one of the commissioners asked, I believe it was Roy Carter from Champions, if he had a recommended number, because he was testifying that he thought 2 was too few, and Roy said 5 or 6 would be doable. That they never typically take 10 out, but if we had to set something in, 5 or 6 would be what he would recommend as being appropriate. The reason I bring that up is I know there is some concern, at least from the commissioner's standpoint, that 2 may be too far in one direction, that maybe there's a point where you can get to a place that's in between and then see how that goes before you move forward. But it's up to you guys. I just wanted to bring that forth to for your consideration. So with that, I don't know if you want to open up for comments or have any questions about what I just said.
First, I guess what we need to do is determine whether to agree on the change that Tony needs to make in the statute, right?
Right. It was reproposed at the meeting, and what that means is they can adopt it in February as is.
Right.
And they did that just to make sure there wasn't they got the ball rolling on it. But you're right. It's up to the committee to determine whether or not you agree with this change,
Right.
and whether you want to make a different recommendation to the commission based on that.
Okay. So we can break it into 2 parts. One is agree with this change and then talk about, or is this all one?
No, you can do it however.
And then talk about the change in the number of, reopen the discussion for how many people we want to do.
If you guys want to
2
do
or
that,
5.
yes.
So do you guys want to reopen that discussion first?
I prefer not to.
Yeah.
Do we want to vote on this first and then discuss that?
This,
Yeah.
this is what we actually thought we were
This
approving.
is,
Right, so let's, number one, let's go ahead and make a motion, somebody make a motion to approve Tony's change, which would correct.
Right. It would correct that. I don't know if you want it. So I'm trying to make sure how we do this because there is at least one person that wants to have a comment. I don't know if there's anybody else that might. I don't know if it'll influence your decision about moving forward or not. Before you vote, or you can, and Carrie, I don't know if you can weigh in on the best way to do this. If they could just vote to agree on this change and then vote further afterwards to move the rule forward to the commission based on whatever other discussions they have.
Sure, they could do that, or they could make a motion and then take comments, but
Okay.
doing it piecemeal is fine. We don't
Okay.
have, we can be a little informal here.
Okay, so if you want to just make a motion about this correction and then
Yeah.
we can,
I'd
okay.
rather just get this out of the way,
Gotcha.
and then we can move on with
Okay.
Stan and
Sure.
whoever
Sure.
Scott wants to speak.
So I'll make a motion to approve Tony's correction of the 535, 213 D1A. Is that right?
G1A. That's all
See
right.
it.
And just,
And do I have a second?
Second.
Second. Okay. And all in favor of accepting Tony's change?
Aye.
Okay, so we passed
Aye.
that. Thank you, Barbara. Okay, so now, let's move on to, let's first listen to what Mr. Harbuck has to say on this. Stan, can you hear us?
Yes, can you hear me okay?
Yeah, so why don't you go ahead, and you have 3 minutes, but go ahead and give us your opinion on this subject.
I think if you look at the combination of eliminating the ride-along option that we've just discussed before, the 1660 option, and you also combine that with the fact that you're reducing the numbers from 10 down to 2. And, I actually agree with bringing it from 10 down to 2. But when you combine that, with the fact that you're getting rid of the other option for the ride-along and experience module combination, you actually will be making it 15 times more difficult, roughly, for people to be able to get their license through the experience system. The reason I'm not in disagreement about going from 10 to 2 is because this has always been something that we've always considered from the beginning is, how can anyone possibly get a good view of what the inspector is seeing and or get a view even around the side of them when there are that many people there. I think 2 is more manageable, but I actually believe that a video program can actually give an even better view than that. And then the student can actually see not only what the inspector is doing with their hands and so forth, but also they can see what they see. They can view what the inspector is viewing. Direct view instead of having to look over their shoulder. So I'm actually in agreement with that, but when you combine that with eliminating this other option, I'm concerned that, it's 15 times, which has an anti-competitive effect. The Sunset Commission in their meeting mentioned concerns about ride-along instructors potentially being competitors. And so I think we've talked about these ride-along and experience module requirements quite a while, for years, and almost every time we always talk about the anti-competitive effect that these can have when they're not necessary. That's still our position now, except that there's now a case that suggests that, anti-competitive rules are not to be considered acceptable when they're unnecessary and when they're just done as an anti-competitive effect. And those are the premise for many of the Sunset standards that the Sunset Commission uses. That case, North Carolina Dental, is the one that the Sunset Commission uses to build many of their standards, and that's mentioned in their preface for their standards, their model standards. That's what we've always said. We've never referenced a case before. That case came out in 2015. It's been around a long time, but we had just hoped that members of the committee would be aware of that. But since the Sunset Commission has made it part of the premise for their standards, we brought it up here as well in our notes. Also mentioned that, as I did before in an earlier meeting, that there is, we although the original premise for getting rid of that 1660 option was so that because no one been licensed under that rule, I mentioned that we have been doing our best to try to get approval under that provision, and we hope that at some point we can be successful. Licensing under a rule doesn't necessarily mean that there is an activity in progress for trying to receive approval under that rule. So I would encourage you to not make either one of these changes. To recommend to the commission that you continue to allow the 6016 option for professional home inspectors, as well as if you're going to take that out, then I think you're just kind of squeezing the balloon in another direction if you go from 10 to 2.
Okay.
Even though I have to agree with you that I think that 10 to 2 is not a bad move overall if you left the option in there, the 6016 option. And thank you very much.
Okay, thank you,
Madam
Stan,
Chair.
we appreciate it. And Scott?
Madam Chair?
Yes, ma'am.
Can I just, since Mr. Harbuck brought it up, can I just clarify this North Carolina case in case it's of concern to anybody?
Yes, please, I would appreciate that.
Just want to make sure that everybody understands that the North Carolina Dental Board case dealt with a board that was consisted of more than a majority, a huge majority of license holders, dentists. And they prohibited people without a dentist license from offering tooth whitening services and tooth whitening products. Now, that was not something that was in their statutory charge, and that's why this all came about. Okay? So what the Supreme Court said is in that case, yes, that was anti-competitive and they need to safeguard the nation's free market structure. But in this particular case, and what the Supreme Court said was if the legislature has given the clear authority for it, and the legislature has put it in there for other good reason, then it's not considered antitrust. In our particular case, the legislature has stated that 40 hours, up to 40 hours of ride-along or hands-on training is appropriate for the consumer protection aspect of making sure that the license holder, when they are licensed, has at least had some hands-on experience. Further, recall that the fast track, if you will, or this track where you can just do the 40 hours of ride-along, is replacing an apprenticeship standard of 175 inspections. So I don't think that making a change to the rule which eliminates this video type program, if you don't think that that's adequate or necessary for hands-on, or reducing the number from 10, and we'll talk about that later. I think Tony's going to visit with you about that in a second, the number, whether it should be 2 or something else, down from 10. None of that is going to subject either the commission or this committee to the type of problem that was created in the North Carolina Dental Board case. So although that may be Mr. Harbuck's opinion, I think it's a misinterpretation, and I didn't want anybody to be misled on that.
Thank you very much. I appreciate the clarification.
Scott Regan. I have one question. Is there an amount of limited instructors at one dwelling at a time?
No.
No.
So you can have 10 people in a house again?
Look, you can have 10 instructors with up to 20 students, 2 per instructor. You can have multiple instructors.
The way it's currently proposed is there'd be, it's not limited per course, it's per instructor, and it's 2 per instructor.
And the old limitation of how many houses you had to have,
Sure.
it wasn't practical. I mean, there isn't any reason 2 or 3 instructors could go to a house with their pair of guys, and one's on top, one's in the attic, one's in the house. They're not gonna get, but if you had multiple instructors with 10 students each at one house, that was
my
the problem.
It's
yeah.
not limited in here.
No, we removed, so when we brought it down to a real small ratio, we removed the restriction that said that there couldn't be multiple instructors at the same house.
All right, thank you.
Because that made sense.
Yes, that was my question. Yep.
If there weren't any more comments, I wanted to make clarify one other thing.
No, that he was.
Okay. I just wanted to mention something that I mentioned to the commission as well, because I think it's important to the conversation here. The ride-along requirement went into effect in March of 2015. Since that date, there's been a 27% increase in active, not just inspector license, but active inspector licenses. We've gone from, this is in September, so it's a little bit more in October. We went from 2,560 active inspectors in March of 2015 to 3,507 in September. So, you know, the argument that the ride-along is causing an issue with people becoming licensed, I mean, I don't know, I leave that to be able to determine, but it's been a 27% increase since it went into effect.
Yeah. I look at the 15 times more difficult argument. I don't necessarily myself see that as being valid because the 1660 rule isn't being used. So in its current state, it's 15 times more difficult anyway. And if we have that kind of an increase, where we're looking at what over 1,600 of the 3,200 actively licensed professional inspectors have been licensed within the last 2 years, I just don't see that as being an argument that it's creating that much of a burden if we take that rule out. I think that 1660 rule was done because when we put that into place in 2015, there was this huge concern about whether we would have enough ride-along instructors, whether we could get those things done. And for the first year or two, I think we had less than 30 ride-along instructors that were actually licensed, and now we're over 70. And I just don't see that as being, you know, that much more difficult. I don't see a reason why we can't get a rule that is not being currently used. It's obviously not hindering the market. It's not hindering the ability of inspectors to be there. As far as committee members being liable, I don't necessarily agree with that with antitrust, because obviously there's a substantial number of inspectors that have been licensed over the last 2 years, or even over the last 3 since we put this in place. And the video, I don't agree with the video taking place of the ride-alongs at all. The whole point of doing the ride-alongs was to physically be there with an instructor, to interact, to be able to look at that and point and touch, and be able to physically be there and interact with your instructor to get that better education. I just don't think video covers that. I think there's options for video education throughout our standards and pre-licensure. I don't think that needs to be involved in the ride-alongs. The ride-alongs should physically be riding along, doing inspections with somebody you can interact with, ask questions, and touch the actual items.
I agree. Steve, Brad, Will, Sean? Thoughts?
Good with 2.
Yeah, I'm still good with 2 also, and I mean, if you're outside, okay, it might be one thing, but you're talking about going in attics, climbing on roofs, being around an electrical panel, you know.
I agree from the standpoint of the instructor that just 2 people's income isn't a whole lot of money, but I think if you get into 3 or more, you're starting to crowd in some of these tight spaces you get into. So 2 is a good number for me.
I mean, I've had 2 of my employees that one just finished his hands-on ride-along experience in the last 2 weeks. And he said there were like 10 of them at the house, with I think maybe 2 instructors. And he said that, yeah, he tried to hang on with the instructor as much as he could, but he says he'd turn around, guys are wandering around the house. So I think that's a problem that if there were 2 or 3 I'm comfortable with, that should fix it. Now, an instructor may not keep them herded together, but that's a problem there.
Plus, this doesn't have to be through a school. I mean, it's,
No.
you know,
Yes.
anybody who's registered as a licensed ride-along instructor, they can get those courses and sign off for those hours. I can do it at, you know, and I think I actually am registered as a ride-along. You know, if somebody calls me up, hey, I need ride-along hours. Okay, I'm going to charge you X amount, you know, to go along with me or whatever the case may be. You can set that based on what you feel your time is worth. to help educate somebody else. But it isn't restricted to just the schools, and I think that's one of the other components that people aren't really thinking about.
But they are, for the most part, packaged into.
They are packaging
Yeah.
them in, but that's
Yeah.
not that, because of the way the school is packaging, but
Doesn't
that's
mean they
not
don't have to.
necessary. You know, I was
Yeah.
one that's pretty adamant about two, and I'm still pretty adamant about two.
And Tony, the commission just basically wanted us to revisit it because of some of the
They have some
testimony.
concerns about it. The commission does. So that's not. I don't want to speak for them, but they
Right.
did have some concerns at the meeting about whether or not that number was too restrictive. We have not
So Tony, I think you can summarize.
summarized what.
I think you can summarize their concern and maybe some of the, for those that didn't listen in at the commission meeting, some of the,
Well, it's so.
comments that were
so
made.
the biggest concern is if providers, because we have not heard any real or gotten any real comments from anybody that's not related to a provider in one way or another. But providers are concerned that they're going to have to raise the cost of the providing ride-alongs because they're doing it for less people, and that the way to recoup that is to pass that expense on to the inspectors who are, or the applicants who are, or students or whatever, who are assigned into their course. So the concern of the commission was, to the extent that this raises the cost to become an inspector, they want to make sure that the committee weighs that, weighs that towards the benefit of reducing it down to 2 as opposed to someplace in between 10 and 2.
I would pay twice as much to go with one other applicant than 9 to get that tighter education one-on-one with the
Or just not do it with the provider and do it with
Right along.
Brad or
And-
with, anybody else.
Right.
And the commission ought to be concerned about the consumer quality regardless of the price.
I'm not saying they're not.
I know,
Right,
but that's,
but-
my argument would be.
no,
the
they just
commission-
wanted to make sure that y'all had considered
We,
all of
we,
that.
we considered all of that, Carrie, and we're concerned about
Or they
quality
can
education,
take
quality
it.
training, so we're putting out a good product for the consumers of the state of Texas.
Okay.
So I'll make a motion that we leave it to 2.
I'll second.
Okay, all in favor?
Aye.
Okay, so
Any,
it remains.
Dr. Evans?
Aye.
Okay. All right, so this will move forward to the commission in February with that one, well, they proposed it with that change anyway,
Right.
so it'll go forward without any changes from you guys
Right.
based on that. Okay.
Is that all of number 8? Is that?
Yeah, and the reason why those other 2 rules were attached was because
The package?
they reference 213, the other 2 rules do, so they all had to be reproposed even though there weren't any changes made to them. So, yeah.
And from the school side, if down the road we're looking at reducing some of the hours, that would offset the cost of
It
more
could.
instructors.
It could. Yeah.
Big
Okay,
picture.
so, any more discussion, or, okay. So agenda item 9, discussion and possible action regarding amendments to 22 TAC Chapter 535, Subchapter R, proposed at the November 15th, 2018 commission meeting.
These were the rules that were missed during the last rule review that were brought before the committee in October that you moved forward to propose them. They were proposed at the November meeting. We haven't received any comments about them, so this is just in front of you in case if there were any comments or there were any concerns with these going forward as proposed.
So this is-
If memory serves me, that was just a cleanup.
Yeah, there's a couple of clarifications, cleanup about language to make it consistent.
Consistent, yeah.
In terms of the consumer notice, make it consistent with what we do and other things. So yeah, there wasn't anything. This was a typo here. So
Have we seen this before?
in October.
So we saw it, so it's the same thing we saw.
It's the same thing. This is, again, we always bring these forward to you guys after the proposal in case we get any comments and there's anything that has come up that makes you want to reconsider or change anything. So this is just before you to determine whether or not you're good with these as proposed, and then we can recommend to the commission that they go forward this way.
Recommend approval by the commission.
Second?
Second.
Okay, all in favor?
Aye.
Barbara?
Aye. Aye.
Thank you.
Aye.
Okay, so the motion passes. agenda item 10, discussion and possible action regarding providing an inspection report in addition to the required REI 7-5.
This was just a discussion that I think Tony and I talked about maybe, and I'm sure people have run across this. I had an inspector in our local area who was approached by, I guess call it a relocation company, that wanted an inspection on property. And it was probably like we're thinking, relocating an employee, they're buying the house or selling it for the employee. And they were not interested, because they're out of state, in a TREC inspection. They did not want it. The inspector kind of emailed me going, I'm inspecting this thing, I'm gonna have to give them a TREC inspection, right? And I'm saying, yeah. And he goes, okay, so the question what he felt was gonna happen is, he would fill out their checklist inspection, he would do a TREC inspection, that part would get deleted, and the TREC inspection would be used as promoting the sale of the home. And he was questioning his liability because that one had his name on it. And it's like, just wanted to verify that these things happen out there, and that if an inspector is approached to fill out that relocation inspection, that he is obligated, or can he just put the disclaimer on there that we have on the departure of the inspection, if we're using a form other than the TREC, that this is not a TREC inspection. He himself, which I was gonna do, is provide a TREC inspection with it. But would that information that we would use, that we can use in our rules, it says if we're using, because that's kind of geared for, I think it does say like government or state forms or something. It doesn't talk about private forms from like a relocation.
I think the governing, and correct me if I'm wrong, but the governing thing here would be whether it's a transaction, if it's
a
buy.
relocation,
Yeah.
it is a buy, and we hashed that out previously on numerous occasions, and the decision and the ruling was they had to do the TREC form. They could do the other one in addition.
Yep.
Yeah, there's nothing prohibiting some. This also comes up when when you're using. And I noticed this when I went to the DePria conference. There's vendors there selling software, and they're national companies, so they have different forms they do. But so they provide their software form, but they also provide the TREC form as well. So the consumer gets two forms, and whether or not that's an issue or not, there's nothing that says, so long as you're providing the TREC form, and you can weigh in on this if you want to, but or if you need to, probably. If you're providing the TREC form, that you can't, that there's, the additional information is I don't believe is prohibited.
And the discussion kind of evolved that you touched on is inspectors that go out and do phase inspections. And that question came up. It's been a fairly popular one on some of the Facebook posts, is at what point is the TREC inspection required? And I think we defined that in the last major update, substantially completed. So if you're out there for the consumer doing phase inspections, you're beyond the scope of TREC. A consumer cannot complain to TREC because you failed to miss things on a framing inspection. Most of us may not use, a TREC form, but there was traffic floating around from other inspectors that's saying no TREC requires to use the 7.5 for phase inspections. They don't.
Never have.
Never have, and in my opinion, it's not appropriate. There's no places, if you're doing phase, you are probably doing code inspections.
Right.
And our form isn't created for that. It's not very accommodating to it. But it's kind of the same thing. If you're doing that, the question is, do you put that disclaimer on there that this is not a TREC inspection? I think it's kind of obvious if you're inspecting a foundation, it's not a home inspection.
Right.
But it appears that if you're a licensed TREC inspector and you're doing any kind of inspection, that disclaimer appears to need to be there.
Any relocation
But I
company
think-
that I did, I just added their inspection form to the end of my report.
There's no,
I just did it that way.
There's no prohibition that I'm aware of using your TREC license number in something outside of a home inspection.
but it doesn't mean anything.
Yeah.
But I
Essential
do think,
qualification.
and correct me if I'm wrong, I don't think if you're doing an inspection for relocation and it is part of a buying or a selling and you have to do 7-5, I don't think you can add the disclaimer to it, can you?
Well, to
No.
the relocation.
The relocation
form.
form.
Oh, to the
So question-
relocation
so
form.
if-
I see what
so
you're
if-
saying.
in his scenario, he was gonna fill out the relocation inspection checklist, which was more of just a
Right,
checkbox.
right.
But he was gonna provide a home inspection, but on the relocation form, he was gonna put that comment that this is not a home inspection because the two can be separated if they didn't want it.
I got you.
And provide the relocation one to potential buyers in Texas.
So who receives, I'm looking at this relocation form, and so when he did this inspection, is he doing it for the reload company, or is he
Yes.
doing it for
They are the
the
client.
buyer of
They're the
house?
buyer, well, they may be the buyer and they may not.
Well, the relocation company
Is
is the
the
one
buyer.
that
The
hired
client.
him.
They're the ones
to do
paying
it.
for it.
They are the client.
So
They're
they
not
could
the-
very well just take the truck one that they don't want and toss it.
Well, that was his contention is what was his liability because the relocation one will have his name on it as an inspector in Texas
Right.
and it's not a Trek form. And he was his fix might be attaching the two together, which would make it harder to remove. But this was just a discussion. There was no, kind of out between the other inspectors. Is this a concern, or is that the best way to handle it? Do both of them?
Yep, that's the way we'd handle it left.
But could he do just the relocation with the disclaimer at the
No.
bottom that this is not a home inspection?
No.
No, there's an interested party under contract for the.
He'd have to do the
purchase.
Trek form.
You'd have to Trek.
We
form.
have
Because it
Interested
is
party.
a substantially
He's trying to answer
completed
your
house.
question.
It's a complete-
Yeah, I basically agree with a lot of what y'all said. If we got a complaint that just sent in this form, we would think there's liability, but if they produced, I gave them the Trek inspection report, they just threw it away, that would comply. So my understanding is pretty much what Brad said earlier about this too, that they better do that report. If they do something extra, that's different.
Yeah.
Okay. So that's pretty clear cut.
That's,
to you.
and that's, so if there's because that traffic is out there on the web and there were all kinds of, lawyers out there that were saying, oh, Trek is required, that, and if you don't do a Trek inspection form, when you go do your foundation inspection, you're gonna get hammered, and then the question also about their relocation one, it meets the requirements, it's substantially complete.
Right.
So you would need, if you were a Trek inspector and you were looking at it, it would require a Trek inspection. And there's the only time you can use that disclaimer paragraph is something that would not qualify for Trek, which would be not substantially complete.
Or a re-inspection, or.
Yes, those
Single
type
yeah.
of things.
Right.
But if the home is substantially complete and somebody approaches you to do an inspection, you can do theirs, but Trek inspection goes with it.
Okay.
Correct.
Does that make sense?
Yep.
Yes.
Any questions from anybody?
Actually, I just comment like Catherine, it's a pre, I was just kind of looking, because I remember having taught this class in many years in the past. And there's an allowance, it seems like, in the report section that makes some allowance for an entity requiring the use of a different report form, as long as it's placed on there that this is exclusively for that purpose.
Well, that was the.
We might want to review.
Well, that was the gray
restrictions.
area is that in the context of a home not substantially complete, like construction inspections?
No, it says this section does not apply, and the big section is inspection reports. And this I got from the front desk about 15 minutes ago.
Yep.
So I think it's.
Oh, but make you pay for it.
Oh, it's not current then.
Yeah, she made me plug it down. Anyway.
There you go.
So does that change any of, no? Okay.
It would be safe to do a Trek inspection with anything else,
Okay.
if the home is finished.
If the home is substantially complete.
Yes.
And it's as part of a real
It
estate
meets,
transaction.
it meets our little checklist of all the things that have to be in place to require it.
Well, that's good information. Okay, any other questions? Yeah? Agenda item 11, update regarding broker-required payment for inclusion on preferred service provider lists and possible conflict with 22 TAC 535-220, professional conduct and ethics. And this had to do with, the
Carrie, do you want to talk about this, or do you want me to give an update?
Yeah, I'll talk about the what's coming up in January. The Broker Responsibility Working Group has this on their agenda to discuss, and so we're going to be looking at rules for real estate license holders to sort of parallel, I think, what we have for the inspectors, so that to do away with this conflict. Because, and like I said, I don't know which way that they will go, whether we'll change the requirement on the inspector side. My preference is to put in a requirement on the real estate side, because quite honestly, I think even though we don't have jurisdiction over RESPA, I think this practice is a violation, or could be a violation depending on how they do it, of RESPA, and that puts the license holders at risk as well, the real estate license holders. So yeah, we're going to be delving into this and looking at the options, but the chair of the Broker Responsibility Working Group has acknowledged this issue needs to be addressed. So that will happen in January, and we'll report back on what they come up with at your February meeting.
And if I could just add, the reason why it's waiting until January was when you guys asked that it be pushed forward to the Broker Responsibility Working Group, their agenda had already been set, and it could have been added earlier than that. So this is the earliest they could take it up.
Okay. Well, I'm-
There was a well-written article
Oh,
in
that's another thing. Thank you.
in
Thank you,
the
Brad.
advisor.
Yeah, on the webpage, there's an article discussing that I think the Enforcement Division wrote, maybe, about, no?
We
Participated about this particular issue. So I always forget that's out there, but yeah, that was
Yeah,
something we
that
put
was
out
the
there to
last.
help people get educated about this
Should
particular
be sent to
topic.
all brokers and all realtors.
Now, can I ask, why do they do this? Is it just for the purpose of money?
Yeah.
The brokers are just trying to make money.
Agreed.
It's an extra
And they're
revenue, it's another
making-
revenue source.
It's a revenue stream for them,
It pays
of
for
all
their
of the people
collateral.
that are involved in a real estate transaction, because obviously it's not just inspectors, they do it to title companies, and they do it to.
Surveyors, they do it to
Exactly,
everybody, insurance
to be put on
companies.
their preferential.
Landscapers, everybody.
Yeah, so it's
Yeah.
basically just for those people to be able to make extra money off of everyone else that's involved in their transaction.
Not that they're the best, they're just the ones that coughed up the biggest check.
Right, exactly. It's not proving anything other than that
No.
they were willing to give money to
They
a
can be bought,
brokerage.
Which misleads the consumer.
It is misleading.
No, and that's
Right.
why that prohibition's in there on the inspector side, you know? And I think every inspector I've talked to is appreciative of that, actually.
Yeah,
They
it's-
like that independent
But it's
issues there.
often hidden in the advertising costs that you just want to advertise with them.
Right. Right.
Can we get some representation from this committee on that working group so that we can be involved in that process?
Isn't Carrie our representation?
Well, I'd like to have.
Yeah, I mean, I'm there, but you can, if you want to have somebody from the inspector committee go and attend that meeting to talk on that item, I think that's a great idea.
All right. I mean, I was the one who initially brought it up, so I'd be more than happy to follow up with that.
All right.
And Leah, as a broker too, you can
Yeah.
also give
Right.
excellent insights on
Yeah.
it.
Yeah, I think that's a great idea, Lee.
I'm fine with that, because that needs.
I'll make sure I include you on our agenda when we send it out on time and call in information.
Perfect, thank you.
I'll tell you what the date is, you can add it to your calendar.
Thank you. Next question.
Thank you, Carrie. Any other discussion from the committee members on agenda item 11? All right, so we shall move on. Agenda item 12 is request for future meeting agenda items. And-
So I have the agenda item about the 3-day requirement for providing the inspection report and whether or not the whole payment issue. We'll bring this issue up as well, the one we just discussed, because we'll have the Broker Responsibility Working Group will have met at that point. So.
Yeah, they meet on January 10th, by the way.
There you go.
And
So.
the definition of
Text her reminder on January.
present is probably the answer. On the report,
Yeah,
providing
okay.
the report, the definition of providing sounds like it might be the question.
Delivering.
Probably 10. Here. Yeah.
I think it's
Delivery
called
of the report. Delivery, I think it did, yeah, delivery.
So,
Like he said, delivery.
was there any other issues that I
Just
want to
definition
make
of
sure that,
delivery.
when I'm doing the minutes, I'll watch the meeting anyway, but just to make sure there wasn't anything that anyone else wanted to make sure wasn't on or is on a future agenda.
Yeah, I think everything else, so our next meeting is the February, we've already got that set, that's our February.
Yeah, and so you'll vote for officers.
Right.
That'll be on the agenda.
What day is it?
It's the
Fourth.
Yeah.
I probably ran in agenda item 12 just into that, but we already had that meeting date set, so.
Yeah.
So February 4th, okay. And that's also the same, that's also where everybody can get continuing education.
Absolutely.
That meeting.
Does that include us?
Yep.
Yeah, we get it.
Just wanted to clarify. Everybody.
Bring your cousins.
Everybody
and
meets,
brothers.
I understand.
And do you guys, Priya, do you guys send a notice out to all your guys, your members about the extra hours, right? Extra 2 hours in February?
It's also put in the advisor.
Yeah, I know, you're to Priya, but they're Terry.
No, they're not.
Oh, you're not Terry?
Are we still on 12?
I'm sorry.
That's okay.
I didn't know you guys. Go
We
ahead.
can't,
We're on 12 requests, well, yes, requests for future meeting agenda.
Could we consider continuing education for participants and committee members for other meetings, not just that
I would
one?
like to talk about that, actually, to revisit that it could be other meetings other than just that one, because sometimes it's not convenient.
well,
for
the
everybody to
reason,
come on one
if
day.
if I may
Oh,
play
staff.
devil's advocate,
Yeah,
is
sorry.
staff's got to be here to monitor it. And it's just, the commission and the board, the appraiser board, have one meeting, it's every other February. The inspector committee is every February, up to a certain amount of hours. But you also don't want to necessarily negate other continuing education based on just the attend. I mean, it's
Maybe
important
putting
that
a limit
people
on it
attend.
of like 8 hours total for the year?
Well, you obviously can read, but I just wanted to bring that up. The reason why it's one meeting is in consideration of staff having to be here to monitor.
Understood.
Monitor the meetings.
When you say monitor, just,
Make sure people aren't coming and going and all
Oh,
that. So it's just like
okay.
any other course.
Any other
At-
class,
At the end of it, you have to make sure you're here the whole time.
Do we get to
Okay.
evaluate you through the year?
Committee members that stay here the whole time.
We're gonna do
committee
instructor
members?
evaluations on you guys.
That's fine.
Yeah.
That's fine.
Great.
So
That'll
can we
be
do
fun,
that as a
Tony.
discussion item for the next month?
Yes, we can still be in discussion, item, absolutely. All right, I already have it.
And we will have probably items from the education committee.
Yeah. Well, I'll
Yeah,
bring
the
those to
report.
the chair. that we
Yeah,
can-
once you guys have met, anything from the SAP, if you guys aren't meeting
We don't
again
plan to
until.
meet until after the next.
Until after February.
And I may, not that it needs to be in a future agenda item, but I may have some legislative updates at that point. We should know a little bit of something by February.
About sunset, yeah. All right, anything else from anybody out there? Yeah. So request for future meeting agenda items is complete, and agenda item 13, discussion of future meeting dates, and we meet in February on the 4th. That's our next date,
No.
where we also will have
What
new.
time?
Huh?
Did we set a time on that?
10
10
a.m.
Actually, I'll use it once more.
Yeah, you're here for one more meeting at least.
Education.
Well, no,
Huh?
you're not off until the
Replace.
new appointments, which will be mid-February, so you still have the February meeting too.
Maybe.
Give Larry Foster a 20 to get someone in for your position.
Okay, so we will adjourn the meeting. It is 1 p.m.
Thank you, everybody. Thanks, everyone on the phone.